Hi, I'm Mike Smith, estate planning attorney with Smith Barid LLC and one half of the Estate Planning Guys. Today I want to talk to you about IRAs. For many of our clients, that's one of the largest assets in their estate. And so when you think about estate planning, it's very important to think about your IRA and how it will be treated when you pass away. In 2019, Congress passed something called the Secure Act. It went into effect on January 1st, 2020. Now, the Secure Act made various changes to our retirement accounts. When I say retirement accounts, we're talking about things like IRAs, 401ks, 403bs, etc. But basically any qualified retirement accounts. And it made some changes to how those accounts are handled. One of the big changes from an estate planning standpoint is that when you die, the person that you've named as your beneficiary on your IRA will have 10 years to withdraw the assets from the IRA. So prior to the Secure Act, beneficiaries could take required minimum distributions based on their own life expectancy. And so that gave you the ability to stretch those out over a long period of time. That allowed beneficiaries to only take a small portion of the IRA out every year. Now, since passage of the Secure Act, all of the funds have to be withdrawn from the IRA within 10 years. So if you think about that, if you take a large distribution from an IRA, say in year 10 or in year 1, that could push you into a much higher tax bracket and end up costing your beneficiary far more in taxes than under the old regime where they could stretch it out over a period of time. So there's basically two approaches that you can take to minimizing taxes on IRA distributions. The first one is that you can spread out those distributions over 10 years. So you could take 1/10 of that 10-year of that IRA every year for 10 years until you've distributed the entire thing. That obviously spreads it out over a longer period of time. The one drawback to that is that you lose the ability to defer any income earned over that time period. The second approach would be that you would hold the entire IRA for that 10-year period. What that does is it gives you the ability to continue to build that asset over that 10-year period. And so if you are able to get good returns in the market, we know that's not all guaranteed, but generally the stock market has very good returns if you look at it historically. So if you're able to keep the money in the IRA over that 10-year period of time, then you can continue to grow tax deferred the value of the IRA. And when you take it out, yes, there will be still a sizable tax. So if you grow that over a 10-year period of time, there will be a sizable tax impact when you withdraw it. But hopefully you've been able to earn enough over that 10-year period of time to cover the additional income tax that you're going to have to pay. So there's a couple of different approaches that you could take to minimizing taxes on an IRA distribution under the Secure Act. I'm Mike Smith, estate planning attorney with Smith Barid LLC and one half of the Estate Planning Guys.